Good morning. Welcome. Those that would like to, please do feel free to remove your mask for the purpose of the argument. We appreciate everybody maintaining their space. We are here for oral argument in CV19-0635 Zambrano versus MNRC et al. As you may know, we record and live stream these proceedings, so please give your name and the name of your client when you begin. And according to our current protocol, as you're aware, you will each argue from counsel table. And you have a maximum of 20 minutes per side, although you're not required to use all of that time. We do require you, however, to keep track of your time, and we recognize that we've made that a little bit more difficult by keeping you away from the timer itself. So we encourage you to do what you need to do to take a look at that if you want to stand up, to argue, or periodically look, and I will try to give you some signposts. But we appreciate your working with us in the current time. Do keep in mind we've read all the briefing, yes, all of the briefing. We have studied the record. We've discussed the case in conference this morning. And so bear that in mind as you make your arguments. And with that, you may proceed.
Thank you. May it please the court, Darian Shookham for Appellant Tina Zambrano. I appreciate that we were allowed to do this live. It does feel a little bit strange, but it's nice to be out of the office. It's amazing how things can change in 6 months. I wasn't sure I'd remember how to tie my tie. In any event, and I apologize about the number of pages on behalf of everybody collectively. I know it was quite a bit, but thank you for getting through that. So we are here on Ms. Sambrano's appeal from the trial court's ruling granting summary judgment for the builder and seller on a breach of implied warranty claim asserted by Ms. Zambrano regarding her single-family home. The trial court's ruling, in a nutshell, was based on a purported disclaimer of the implied warranty in the sales agreement. So at stake is whether this court will uphold the long-standing protection provided for innocent purchasers in Arizona by the implied warranty. As we all know, buying a home is a big part of the American dream. That dream, unfortunately, can become a bit of a nightmare if there are construction problems in the home. And that's especially true if there isn't an available legal remedy. So recognizing this peril and the peril of caveat emptor, Arizona courts across a 10-year span from roughly 1979 to 1989 imposed the implied warranty in residential sales, extended that implied warranty to subsequent purchasers, and then held that the implied warranty could not be disclaimed by the seller by contract. So that is the sort of the lay of the land that the trial court had in front of it. But notwithstanding this precedent, the trial court enforced the contractual disclaimer of the implied warranty. So we've asked the court to consider two issues. First, whether the trial court erred by finding that the implied warranty could be disclaimed or waived by contract. And then second, whether the trial court erred by finding that the contractual disclaimer could be enforced by Scott Holmes, who admittedly is not a party to the contract. And I think as we've demonstrated in the briefs and as I'll try to reiterate today, the trial court erred in both of those regards. So I want to first talk about the implied warranty. Again, we assert that the trial court erred by finding that the implied warranty could be disclaimed or waived by contract.
Counsel, isn't it true that at least several other jurisdictions have in fact confirmed that the implied warranty may be waived? And why wouldn't, given the somewhat recent case law from our Supreme Court, seemingly making it very clear that there is a robust freedom to contract principle in Arizona, why wouldn't we follow the lead of those other states that have gone ahead and said, yes, you may. Now, I'm not talking about maybe the contingencies or the particulars of those waivers or that those courts put in place, but just on the concept of waiver, why isn't that a fair approach to resolving this situation?
Yeah, that is a very good question and something that I was going to get to. And it raises a few points. One is whether there is a distinction between disclaimer and waiver. In other words, a seller disclaims his obligation or responsibility. A buyer waives his rights. And it's used sort of interchangeably in some of the case law. I don't think the trial court in this case made that distinction, but the provision itself speaks to the seller disclaims and the buyer waives the implied warranty. So that's one issue. In terms of other states or other jurisdictions finding that a buyer could waive the implied warranty, I believe that's true. There are also jurisdictions who have held that the buyer cannot do that. When you're talking about waiver as opposed to disclaimer, I think what you need to have is a knowing waiver. And so then we get into an issue of whether that was a triable issue of fact. In other words, if the trial court in this case, and it's certainly not explicit in the ruling, but if the trial court determined that Ms. Zambrano had made a knowing waiver, then I think that's outside the purview of what the trial court could do on a motion for summary judgment. Knowing is something that has to be determined by the trier of fact, and we've cited case law in that regard.
So, counsel, let's say we go along with that concept, that it can be waived, and that seems to be consistent with what other states have done and the freedom to contract, and our case law doesn't say one way or the other. So it's really a first issue for us. What is it that we say about a knowing waiver? What gets to a knowing waiver? And I draw an analogy to the knowing waiver to a jury trial in our arbitration clauses that we affirm. Is that the kind of process we're looking at, or is something else that you're suggesting?
I just want to be clear. If you want me to answer regarding I keep wanting to say 1-800-OCATIO like a phone number, 1800-OCATIO, or...
Well, no, please proceed with Judge Goss's question.
Okay. So, again, there is fairly clear law on what constitutes a knowing waiver of a contractual provision. It requires an intentional relinquishment of a known right, and that has to be shown by clear and convincing evidence. So even if the court ultimately determines that there is an opportunity or there is a scenario where a buyer could make a knowing waiver of his or her implied warranty rights, we didn't get there here. It's certainly not shown in the record.
Could you tie this, as Judge Goss kind of indicated, to either an analogize or contrast to the arbitration context? Because I guess that's what I would like to get to. Courts can, at a summary judgment or earlier proceeding, determine that there has been a knowing waiver of the right to a jury trial by signing an arbitration clause. So what's different here? Is something more required here? Is that what you're saying? The knowing in this context is different from that context? Or is that case law, would it be applicable here, assuming we made it past that threshold question?
Well, I think it would always have to be looked at on a case-by-case basis, and I think there's a difference about knowing what arbitration is as a layperson versus knowing what an implied warranty is as a layperson, especially in the context of a pre-printed form contract, which really, that very important right is sort of dismissed in a single sentence or at most in a single paragraph. And this is a situation where there is no discussion about it, there's no negotiation about it, and the buyer obviously hasn't looked at the home because it's yet to be built, so the buyer wouldn't know one way or another the quality of the construction or what they might be waiving.
But what if there were? I mean, what if there had been here? I mean, what in the arbitration context and waiver of a jury trial, yeah, that may be a little bit more common knowledge now, but back in the day, I can't remember the name of the case, but back in the 20 years ago when that first started to hit the courts, I mean, I don't know that rolled off the tongue or was in the mind of most people. So what is it that would help? I mean, isn't the goal here, or one of the goals should be to make both sides of this equation, an important part of society, building homes, buying homes, to make sure there's certainty and the law on both sides. So how do we achieve that? Aren't there some guiding principles that should help us? And we're trying to equate this to, unless you've got a better example, to like something like waiving it in the arbitration context, where where the person has to understand essentially what's going on before they sign that clause.
Well, again, in the context of buying a home, our courts have weighed those considerations about freedom to contract, the rights of the builder versus the rights of the homeowner, and have decided through a line of cases that there is going to be an implied warranty and that it can't be disclaimed by the seller. So that's the starting point. Now, there was no evidence of a knowing waiver in this case we submit, or at the very least it was a triable fact. If the court ultimately decides that there is a scenario where a party can make a knowing waiver of their implied warranty rights, again, that is a different scenario than what was presented to the trial court, and I don't think, at least explicitly, the trial court ruled in that regard. And the case law is very clear. You need clear and convincing evidence to waive that contractual right.
So let me ask you this, because maybe this gets closer to the issue. Is it an objective knowing waiver or subjective? And I think...
You're about 10 minutes.
No, okay. When we look at the arbitration clauses, this tends to be an objective standard. Was it explained? Did they sign it? And we move on. Or are you arguing that this has to be a subjective standard, that every case we're going to have a litigation regarding whether they knowingly waived it subjectively as opposed to objectively?
Well, I think you can have either. What we know from the law is that signing your initials on a pre-printed form contract does not constitute waiver. Now, but
it does in the arbitration clause, basically. You have a separate page, it's pre-printed, and they have to sign it, not initial. I mean, some may initial, I don't know. But it's the same concept.
Well, I would submit that the arbitration clause goes to the forum and not to a fundamental right about whether you have a claim or not regarding the implied warranty, because in many cases, and precisely in this case, the homeowner had no claim if the implied warranty had been eliminated. So it's a little different than saying, well, you can't go to Superior Court, but you can go and exercise your rights.
It's a right to a jury trial you're waiving, though. I mean, it isn't just a forum issue. It's a right to a jury trial that you're waiving.
Agreed. Again, I would submit that it's a bit different. And I have to go back to the case law that makes it very clear that there are certain things that have to be shown for a knowing waiver. It has to be an intentional relinquishment of a known right. Ms. Zambrano testified that she had no knowledge of the implied warranty rights or what she was waiving. There is no evidence contravening that. And so it may be a issue of fact that would go to the jury, and they would determine that Ms. Zambrano or any homeowner in a given case had made a knowing waiver. But I don't think that it rises to the level of something that can be determined on summary judgment, certainly not on the record that the trial court had in front of it.
If you'd like to go back to the 1800 Ocotillo, that'd be great.
Since we talked a little bit about 1800 Ocotillo, I'll jump ahead to that. This is really where I think the trial court went off track. The 1800 Ocotillo decision should not have been controlling in this matter. In 1800 Ocotillo, before the Supreme Court, was a contractual limitation of liability clause, and the question was whether that clause was contrary to public policy. Very different set of facts than the facts that were before the trial court and this court today. It was commercial parties. I think it was a surveyor and a developer. Did not concern the sale of residential property. Did not address the implied warranty or the policy considerations behind the implied warranty. But that essentially was what the trial court latched onto for its ruling. The trial court quotes language from the restatement, second of contracts, which was quoted in 1800 Ocotillo, And I think it's important to read that. The trial court quoted the language, said, absent legislation specifying that a contract term is unenforceable, court should rely on public policy to displace the private ordering of relationships only when the term is contrary to an otherwise identifiable public policy that clearly outweighs any interest in the term's enforcement. In determining whether a provision is unenforceable, courts balance the interest in enforcing the provision against the public policy interest that opposes enforcement. And so, what's the problem here? Well, as a general proposition of law, there's no dispute. That is, in fact, consistent with the holdings of Nastry and Buchanan. The problem with that analysis, or the trial court's analysis that ultimately resulted in a ruling that the implied warranty had been disclaimed, is that it ignores the precedent that we already had in front of us on the exact issue that was before the trial court, a waiver of the implied warranty. And so the application or the analysis of 1800 Ocotillo should have started and ended with the language that I read above, that holding that contract provisions are unenforceable if they violate legislation or other identified public policy. We already had an identified public policy in controlling precedent in Nastry and Buchanan.
So let me ask you, counsel.
Sure.
It suggests to me that if there was just a disclaimer, you're 5 minutes. So if there was just a straight up disclaimer, then that might be problematic. But here there was something given in exchange for the waiver. It wasn't just a disclaimer, it was a waiver, and there was something given. Isn't that different than what you're talking about?
Well, the trial court certainly thought so, but I disagree. The Nastry court held that you cannot displace or replace the implied warranty with a limited warranty for a limited period of time. And
did Nastry involve a limited warranty?
Yes, it did. In fact, the initial case that imposed the implied warranty at Columbia Western, there was also an express warranty, and they nonetheless found for the imposed the implied warranty. But, you know, there are both factual and legal problems with that analysis. There were factual problems because the court sort of made this generalized subjective determination that the limited warranty was equal to or better than the implied warranty in protecting the homeowner, Ms. Zambrano, which is simply not the case. You've seen in my briefs and in the amicus briefs many examples of the exclusions and limitations and statute of limitations and so on in the limited warranty that make the coverage much, much, much more narrow than what is available under the implied warranty.
In some cases broader.
Well, I'll get to that in 1 second, but in fact, for Ms. Zambrano's claim, she would have had no remedy under the implied warranty. The only area where the limited warranty is broader or has a longer available time period than the implied warranty is in regards to, I think, what were called major structural deficiencies. And
You're at 3 minutes.
Thank you, and I'll answer this question and I'll try to reserve my time. And that coverage for major structural deficiencies under the limited warranty, although it lasts for 10 years, the house has to be suffering serious structural damage for that to kick in. And we've admitted, Ms. Zambrano's home didn't rise to that level. It's got some damage from soils movement, but it certainly does not fall within the coverage of the limited warranty for major structural deficiency. So again, she was left with no remedy, and unless there are more questions, I'll reserve my time. Thank you.
Ms. Sambrano invokes public policy.
Could you introduce
I'm sorry.
yourself?
Thank you. I was so wound up, Judge. It was really great. Okay, fire gone. Jim Holland here. I'm appearing on behalf of Scott Holmes and the other defendants. Ms. Zambrano invokes public policy to say that to guide this case, and yet she seeks to avoid and really ignores Arizona's paramount public policy. This court said it best in Consumers International v. Cisco that if there is one thing which public policy requires, it is that people of full age and competent understanding shall have the utmost liberty of contracting. and that their contracts when entered shall be sacred and shall be enforced by the courts of justice. Therefore, you have this paramount public policy. You are not likely to interfere with this freedom of contract. The issue that's being presented before this court then is, can parties contractually define their warranties? Or put another way, does public policy forbid parties from contractually defining their warranties?
So let me ask you this, counsel, then, just
Sure.
kind of tying into the argument, in the discussion we've been having. Could it just be a straight-up waiver and no consideration? Just our agreement is we're going to waive our implied warranty and basically back to caveat emptor.
Well, first of all, it would not be back to caveat emptor, Your Honor, and I can get into that if we need to, but can the law of contract prevail over implied terms? I suppose they could, yes. In this case, we don't have that situation. We're not seeking to avoid the warranty, we're simply seeking to define the warranty. But the law of contract is a right that's actually preserved under the Constitution. The ability to contract and the rights of parties to determine their own destiny that way. Now, we have no quarrel with the concept of the implied warranty. It's public policy, as identified in NASTRI and citing to Powercraft, is to protect the innocent homeowners and to hold home builders accountable. We're seeking to do that. The problem that we have is that we need definition to it, because every truss is going to deflect, but how much deflection is too much deflection? All concrete is going to crack, but how much cracking is too much cracking? And the trouble is, any hairline crack that appears, and we all of a sudden have a question of fact, no judge is able to, under that reasonableness inquiry, able to say, you know what, that's not a defect. By the same token, no matter how bad that defect is, if the builder says, no, that's not a defect, no judge is able to say as a matter of law that it is. So we always are forcing the parties into protracted litigation. And particularly in the type of defect that we're dealing with here with Ms. Zambrano, where we're mainly dealing with essentially stucco cracks and drywall nail pops. And we're dealing with that sort of thing.
Let's
Sure.
talk a little bit about what the contours of this would look like. Let's say that we're with you on the big, huge, broad concept, the overarching concept of the possibility of a waiver.
Mm-hmm.
But we agree, obviously, of the paramount policy concern of enforcing contracts as written and allowing folks to enter them. But there is obviously this other very strong public policy concept that's pretty deeply rooted in our law for several decades of this implied warranty that is there to protect the consumers. Our best analogy we've come up with is this arbitration context. And as you may know, in that context, there had to be some development of under what circumstances has somebody knowingly sufficiently waived their right, this important right to a jury trial. So what's required here? Under what circumstances? Is it enough that somebody initials, a paragraph, the only place in the contract that the term waiver applies? Do they need to be told that there is an implied warranty? What are the contours of that implied warranty? Does the person have to have subjective, or is there some objective measure that we could impute to say under these circumstances they knew their rights, this person knew their rights and affirmatively opted to waive them? Tell us what we would need to say in order to give life to this notion of allowing for a waiver.
That's terrific, Your Honor. And let me see if I can't start out with just the framework of what the courts have said on this. 1984 was a pivotal year for this issue. That was the year in which NASTRI was decided. And we have no issue with NASTRI in terms of saying, look, when you have a non-party who has no way of knowing and doesn't have notice that there even could be a waiver, has no way of knowing what the terms of that waiver or things are, we're not going to impose that. We have no quarrel with that, and that's not what we're facing here. So
let me ask you this. If in this case the house had been sold and there was a new buyer, we'd be back to the implied warranty.
Correct, Your Honor.
Okay.
So we don't have any quarrel with that. What we have is a situation, so there's the NASTRI case. Now in NASTRI, in dicta, they speak of this concept of knowing waiver. The reason why they spoke of it in dicta is because all that NASTRI was really doing was saying our decision here is not applicable to every implied warranty situation or every waiver. What they also do, though, is they're citing to, the reason why they mention knowing waiver is because that's what Colorado had. They're citing to a Colorado case when they talk about that, a couple of them, in fact. But the same time that Nastry was decided, the very same year, we have the Arizona Supreme Court also decide Darner Motors. And in Darner Motors, they say that even with boilerplate contracts, parties are bound to, quote, provisions that were never discussed, examined, read, or understood, close quote. They also, the same year as Nastry, SRP v. Westinghouse is decided. And SRP v. Westinghouse comes 2 months after Nastry, in which the Supreme Court lays out a distinction between contractual waiver and a waiver of contract rights and a waiver of tort claims. And it says this, quote, a party may waive his contract remedies even though he is uninformed as to what he is waiving, is unaware of the waiver, and would not have entered into the transaction had he known about it, close quote. That's SRP v. Westinghouse, Arizona Supreme Court, addressing this very issue. So there is not...
Addressing the issue of waiver...
Addressing the issue of waiver in contract context.
Do you know
Okay, but let's focus on an implied waiver of a warranty that's imposed by law. It's a little different than just waiving some of the other things that might be waived under contract, and the party's ability to do that. What do we do when you're waiving something that occurs out of law? Much like my right to a jury trial doesn't exist under contract. My right to a jury trial exists because of a constitutional provision. What do we do when that is what's being waived?
Sure, Your Honor. And first, let me address real quick this idea that it's arising out of law. The third case, also decided the same year as Nastry, Arizona Supreme Court, Woodward v. Churko, says that the implied warranty of habitability and good workmanship arises out of contract.
I understand that, but it's imposed by law.
It's imposed.
But it's based on contract.
It's imputed. I mean, the Supreme Court has made it very clear. It's baked into the contract. It's part of the contract. In the Sierra Enterprises case, just from the last year, didn't the court say this is a part of our law? Now, the implied warranty, it could be because it is part of a construction contract, a sales contract.
It is part of the contract. And part of the contract, it would be subject to the same standards of contract law. But if the court were to say that it needs some sort of a knowing standard, it clearly does not require a knowing standard in terms of climbing into the heads of the purchasers and determining what they subjectively understand. Okay? In fact, this court decided this year in Rizzio v. Surpass Senior Living, LLC, quote, nothing in applicable Arizona law requires a drafter to explain the provisions of standardized contracts, close quote. So there is no requirement anywhere that's ever been said we have to get into the subjective understanding of the parties.
So let's talk about the objective standard then. Let's say that we conclude that some objective knowing waiver needs to be shown. Has it been shown here? Is it something we need to remand if that's what we do? To let the trial court look and see, hey, is there a knowing waiver here, objectively?
Well, when you get to the objective standard, then let's look at, we're getting more into the facts. We're beyond just the legal concept, but the facts are here. That waiver provision said three things. First of all, it was the only bold language on the page. Secondly, it said three things. Number one, we know that the express warranty is the only waiver, or excuse me, the only warranty that's been given. Number two, all rights that we have with regard to construction of this home are going to be governed by that express warranty. Number three, all other warranties, including, and it names, the implied warranty of habitability and good workmanship, are waived. It says those things expressly. Now, Ms. Zambrano was a real estate broker. She understands these contracts. She initialed that provision, the only bold language on the page. She then also had a separate document, and the separate document said three things. It was one single sheet of paper. It was not a stack. It was not boilerplate. It was not in 8-point font. It was like, I'm going to say around 13-point font, single page. It said three things. Number one, I acknowledge I received this warranty before I signed this contract. Number two, I agree that I am going to read this document because it defines my rights, and I'm going to ask questions if I have any. Part of that is I understand that I can ask a jury, get an attorney to answer any questions, an attorney of my choosing.
So what it sounds like you're saying is, if we were to decide that a knowing standard applies, we would need to vacate and remand to the trial court to make that determination or decide whether it needs to go to a jury.
No, Your Honor. A knowing waiver standard, unless you're going to say that I have to climb into their psyche and say that I know exactly.
9.
Thank you. That I know exactly cognitively what they were understanding, then any other standard, no, we wouldn't, because we had language that was very express. It told them exactly what they were waiving. It told them exactly what their rights were. They acknowledged on a separate piece of paper, and they signed the separate piece of paper saying, I received this, I will read it, I will ask questions, and the final thing I didn't get to is, I understand that my failure to read it or to understand it will not change my rights.
Which essentially is the same as often we see with the arbitration. Separate document, separate acknowledgement.
That's right. In fact, the arbitration arbitration law subjects those type of clauses to, I think, the rule of separability, which basically it's a separate, distinct document. And in this case, that's what we really had. So we had an understanding that they were receiving something, a quid pro quo. They're getting an express warranty that's going to define their rights. If you look at it this way, Your Honor, another way of looking at it is that the implied warranty is really designed to protect the reasonable expectation of the parties. The reasonable expectation, as this court and the Supreme Court have repeatedly said, is what is embodied in the written words that the parties choose. In this case, they expressly chose tolerances within which there would be a defect or there would not. If you have more than 1/8 of an inch vertical displacement in your concrete crack, you've got a defect. If you have less than that, you don't. They chose exactly what were their standards. They could seek others to help them understand that if they wanted to. They could seek attorneys to help explain it if they wanted to. And all of that was in the documents they signed. This was not done in secret, and it was not done somehow imposed on them unknowing.
Counsel, what's your opinion of why other courts, and I have not done an exhaustive research of all 50 states, but just in glancing at a couple of cases, or a case from 2016 from Illinois, another one from 2013 from Idaho, and both of those emphasized, I'll just read part of that, out of the Illinois case, it says, the language of any waiver provision will be strictly construed against the builder vendor, and that to be valid, the waiver must be a conspicuous provision that fully discloses its consequences and establishes that the waiver was in fact the agreement reached by the parties. The Idaho court says the heavy burden placed on the builder is completely justified, but you have to show that there was fully disclosed the consequences of the inclusion, that to show that the agreement was in fact reached. How do we know from reading the language you said that if we were to adopt something like that Ms. Zambrano understood the consequences of her decision? I mean, how did she know, and does the record show she knew what the implied warranty, other than the fact she's a realtor? To me, that doesn't move the needle very far. Did she know what the implied warranty of habitability and workmanship is?
You know, the real problem that we have, Your Honor, is nobody knows what the implied warranty of habitability and workmanship
fair point.
is. Until a jury rules and it renders a verdict, we don't know.
Doesn't that cut against your argument? I mean, you're saying this is a policy that's been around now for 41 years in Arizona with strong underpinnings from both the Supreme Court and this court have blessed it many times. And to say that you can take it out by using the word waive one time in the document and no explanation of what the waiver is, what the theory is, what is the implied warranty? Well, you say there's no definition, then how does one have a knowing waiver?
One can have a knowing waiver. Look, I may not know.
You have 5 minutes.
Thank you, Your Honor. I may not know every detail of any particular document, but I can know when it says this is your only warranty, I can know that. I know that this is my only warranty, and I may not know what else was out there, but I know that if there was something else out there, I've waived it. Now, when I signed my deed of trust on my home I purchased, which, by the way, is just as big a transaction as the purchase itself. Okay, there's a lot of terms in there that even as a young law student, I didn't understand. I still don't know what attornment means. Okay, it has a lot of waivers in there, presentment and waivers of attornment and waivers of all kinds of things that I had no clue what they mean. But I can tell you that under Darner Motors, I'm bound by those terms. I can understand enough to know that when it says it's the only one, that's all I get. Now, it's also important to know what you cited to were the 3 cases cited by Nastry. Nastry, in citing those 3 cases, was not citing the only 3 cases. The truth of the matter is that if Arizona adopts some sort of a standard that doesn't allow these type of waivers, we will stand alone. There are 9 other cases. Turner v. West Hampton Court, it cited Alabama Supreme Court. It says, quote, the principle of freedom of contract permits a party to effectively disclaim the implied warranty of habitability, close quote. What's more important is O'Mara v. Dykeman, also cited to you, Arkansas. In there, they granted summary judgment. The Court of Appeals granted summary judgment. I take that back. I think it was the Arkansas Supreme Court. The same thing can be said in D'Souza v. Lauderdale, and that in there, summary judgment was affirmed. So they are not requiring some heightened standard that cannot allow us to, we're not replacing one factual inquiry for another factual inquiry. We're trying to define people's rights in a way that gives everybody a shot at being able to avoid the expense of litigation, which, after all, that's the public policy even of the arbitration clauses.
Sure, and that would be our goal as well. Counsel, I'd like to circle back briefly to the question of whether waivers should even be permitted. I think you noted in the briefing that the implied covenant of good faith and fair dealing is akin to this, or at least, in fact, I even read your brief to say that they're almost part and parcel or closely related to each other. How do you explain then the fact that the implied covenant of good faith and fair dealing cannot be waived, period? Am I correct on that? I mean, that's my understanding. The Arizona Supreme Court has said that cannot be waived. And yet, we have this policy, this implied warranty, that also has been around for quite a while. And I don't know how long the implied covenant of good faith, maybe back to, I can't remember the name of the case Judge Goss mentioned this morning. But anyway, why can't a person waive the implied covenant of good faith and fair dealing?
The implied covenant of good faith and fair dealing does not create obligations for anybody. It just simply says we're going to preserve people's rights and expectations in those obligations.
Then what's its purpose?
It prevents parties from acting in bad faith. It prevents people from cheating. It prevents, if we go back to the case you might be thinking of is the Teamster case with Wells Fargo Bank. But its purpose is to ensure that somebody doesn't just cheat and play underhanded. That's what the implied, that you don't defeat the underlying expectations of the parties. But the same thing is also said with regard to the implied covenant of good faith and fair dealing, as well as every other implied provision. It is always subject to the parties' agreement. That is, you can never have an implied covenant of good faith and fair dealing obligation that is contrary to the parties' expressed term. It doesn't fit. I believe that's the bike case, Your Honor. So you're always going to, if you're going to have an inquiry on the implied covenant of good faith and fair dealing, it would never be violated in this instance because there's an express contract provision that addresses the parties' rights. And when you expressly address your rights, you don't have implied covenant, you're not relying on implied covenant anymore.
Well, aren't you though?
You have 30 seconds.
And aren't you though, because the implied covenant then applies to those terms. You still have to follow through on those terms.
Absolutely, Your Honor. That's exactly right. And that's what it really comes down to. We are not trying to cheat anybody of the terms that have actually been agreed upon by the parties. But it is not good faith to say that I'm going to sign a document, Ms. Zambrano is going to sign a document, either not understanding what the terms meaning or just choosing to sign knowing that she's not going to abide by that. That's not good faith. That's not what the law allows. It's not what it requires. She signed a document. She was encouraged separately. And question this, what more could Scott Holmes do? We put it in bold writing. We had them separately initial it. We were very express in what was the warranty and what was not going to be allowed. And then we had them sign a separate document saying, please, go get a lawyer if you need one. You need to understand this. Promise us you're going to read it, because this is going to be controlling whether you understand it or not.
Thank you, counsel.
Thank you.
Thank you.
You
Darian
have
Shookham.
225.
Okay, for Appellant Zambrano. Mr. Holland stated a general proposition of law that implied terms are always subject to the express terms of the contract. That is explicitly not correct in this context. The court said in Nastri and Buchanan, we are trumping the contractual terms, irrespective of how they came about, because the implied warranty, the policy considerations behind the implied warranty are so important, we're not going to allow that to go away. Buchanan said unequivocally, any attempt by the seller to disclaim the implied warranty is void. And you could make the argument that any attempt would including also waiver language as the seller in your contract. In other words, if you say disclaims and buyer waives, that's still an attempt by the seller to disclaim the implied warranty because the seller created the contract. With the remaining time, I want to address this issue of whether the knowing waiver is a trial issue of fact to be remanded to the court, to the trial court. It absolutely has to be. Even in the contract itself, what was being waived is unclear. There is an issue of fact as to what Ms. Sambrano would understand. The conflicting language in the contract includes Section 15. It states the only warranty is the limited warranty and that all other express or implied warranties are hereby disclaimed by the seller and its affiliates and waived by the buyer. In the very next sentence, it states any implied warranty that may exist despite the above disclaimer is hereby limited to a 1-year period. And then in section number 29, buyer is advised that buyer may have additional rights, remedies, and warranties beyond those contained in this contract as provided by law. So what would
You have
Ms.
30 seconds.
What would Ms. Zambrano understand, if anything, about what she was waiving? There is no evidence of a knowing waiver in this case. If it is in fact dispositive, it is an issue of fact to go to the trial court for determination. Thank you.
Thank you, counsel, for your arguments. We'll take the matter under advisement and issue our decision in due course. The court will stand in recess to set for the next case.
Thank you very much.